Welcome to Aging Insight with your host, John Ross and Lisa Scholmeyer. This program is made possible by
Welcome everyone back to Aging Insight. My name is Lisa Scholmeyer and I'm here today with John Ross. And John and I are elder law attorneys and our practice is right here in the Arklatex area. We bring Aging Insight to you every week so that we can answer questions that maybe you didn't even know that you had. But we want folks as they go into retirement to have the information that they need to make the decisions that need to be made and be educated about what all is out there in that landscape as we get a little bit older. So, John, welcome back to Aging Insight.
Yeah, getting through your senior years can be a bit of it's not really a straight line.
No.
Kind of a winding, curving road. And part of this is brought on by the fact that you end up having health issues. A lot of times those are cognitive type issues. Yeah. Memory loss is just a normal fact of aging.
Yeah, how many times have people said, oh, I've had a senior moment? Well, a little bit of memory loss, that's just normal aging, so it's not always a cause for any kind of panic.
Right, and a lot of times people will say, because I'm the president of the Alzheimer's Alliance, they'll say, they'll talk to me about Alzheimer's and say, I lost my keys this morning, and maybe I've got a little Alzheimer's, but actually, forgetting where your keys are is just the normal memory loss that comes with aging. Now, compare that, say, to holding your keys and not knowing what to do with them.
Right. Now, that's a different situation.
That's a completely different story. But there's this, oftentimes in our business, we talk about people being competent or incompetent.
Right. Or with capacity or without capacity.
Right. But the reality is that it's not anywhere near that clear.
Yeah, no, it's not that black and white. There's a whole lot of gray area, and as we age, some of us are going to experience a little more of that than others.
Right, and so you might have a little bit of cognitive deficiency. You're just not quite thinking as straight as you used to, all the way to folks who, they're able to exist on their own. They know when their basic needs need to be met. They know when they're hungry, but they might forget that they've eaten shortly after the meal.
Right.
They're no longer hungry any longer, but they can't remember that they were hungry 5 minutes ago and ate. And so you get this broad range and everything in between. But essentially what our topic is today is what we want to talk about is, during this period of cognitive decline, where you're not at your peak performance. You don't have the cognitive function that you had at 30 or at 35 or at 40 even. But you're not incompetent. Oftentimes you may still be living on your own, doing your own thing. And so one of the things that we get to a lot is what actions could you take during that period of time that are still within the legal framework of being okay, and what things would not, and where do you cross this line?
Sure.
Which is kind of a messy deal. Now, we're not talking about it from a medical context.
No, we're talking today about from a legal standpoint of what kind of judgments and actions can you take, or what of your own actions maybe could you void later on if you have got some issues, with that mental acuity. And we always want to start off a discussion on this topic with reminding our viewers that in the state of Texas, the state of Arkansas, in fact in every state in the union, once you turn 18 years of age, you are considered to be a 100% legally competent person to make any kind of choices and judgment calls that you care to make. Now, that doesn't mean that you always exercise good judgment, but legally you're entitled to exercise even bad judgment. So I want to start there, that anything you do after the age of 18, you are considered to have legal capacity to do it. And that is regardless of what your spouse thinks, what your children think, what your parents think, what your doctor thinks, really. Legally, you have full capacity to make any kind of choice or decision.
Yeah, this often comes up in the context of we'll have somebody that'll come in and they'll say, my mother or my father did X. Mm-hmm. They did something. And then the next thing out of their mouth will be, but they have Alzheimer's, or right. But they're schizophrenic, or but they are this. So they've done something, and they are also have some sort of cognitive deficiency. Mm-hmm. And their question is always, was that legal?
Right. Can that that vacuum cleaner that mom purchased, or that annuity that dad got into, there was a pretty slick salesman that came in, and mom or dad really aren't at their best at this point. Are those contracts enforceable, and are they valid?
Right. And so kind of to Lisa's point, is you're starting with a presumption that yes, it was. Because again, legally, you're competent. And so throughout our discussion today, when we're talking about whether or not something is legal or would be legal under any given circumstances, oftentimes you're going to make that determination long after it has occurred.
Right, long after that contract's been entered into, long after those decisions have been made and action taken, and then maybe you look back and realize, maybe there was some compromised thoughts that went into that decision.
Yeah, and those determinations are often, when you're talking about legal determinations, the person who makes a legal determination is not a lawyer. It's a judge.
It's the judge, yes.
And so, don't take our topic today and say, oh, well, that scenario fits my personal situation exactly, so whatever my mom did or my husband did or something, that's completely void and I can just ignore it. It's not that simple. We're just trying to give you the framework of how you should look at these things under any given circumstances, and maybe what you should do to try to prevent it or to fix it once it's already been done.
Yeah. So, why don't we take a break and we come back, and we're going to talk about some of the specific issues that we see, and if you're the senior, some safeguards you might want to take, and if you're the family member of a senior, some of the information and all that you might want to look for if you've got some questions about the capacity of that loved one to function. So we'll be right back after this break.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioners still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight, everybody. I'm your host, John Ross, here with Lisa Scholmeyer, my co-host and business partner and elder law attorney. And we're talking today about what you can do, or maybe what you can't do, or at least not legally do, during a period of incapacity where you're just not thinking the way you always were. And Lisa, I would say that probably the most common context that this comes up is in terms of wills.
Right. Most folks understand that a will is a document that people make while they're living that disposes of their property after their death. And, wills are something that have been around for hundreds and hundreds of years. You see them all the time used in dramatic movies and things like that. But people are pretty familiar with what a will is, and most people have an inkling that there has to be a certain level of mental capacity made by the testator, the person who's making that will, in order to have a valid last will and testament. So we do have to have what we call testamentary capacity at the time that will is made by the testator. And we get this question all the time. Mom was taking pain medication when she made this will, or dad made this will shortly after mom died, and emotionally he was just a wreck, and I can't believe he left part of his estate to my big brother who's been gone and in and out of jail. Dad never would have done that if he'd have been thinking straight. We get a lot of those questions where there are circumstances surrounding the making of the will at the time that people want to question whether or not that will maker, that testator, had capacity at the time. And John, what generally do we presume when a will is presented?
Well, once again, the presumption is that the person was competent when they made it. And when you say somebody has to have testamentary capacity at the time of signing, there's a lot to that little phrase.
Right. There's a lot of punch packed into those two words.
Yeah. So we can kind of start with what is testamentary capacity, and generally, if I know who my natural heirs would be, so if I know that I'm married and that I've got some kids, I need to know who my natural heirs would be. I need to have a general idea of the nature of my estate. So I've got to know what I own, and I've got to be able to know these things. I know I've got a house, and I know I've got a car, and I know I've got some money in the bank. Do I necessarily have to know it down to the dollar figure, or do I just need a general idea? Well, I think generally, as long as I know generally the idea of what I have, that's going to be good enough. And then the last element is that I'm able to hold those two concepts together in my mind for a period of time long enough to execute that document. So, for example, maybe I've had a head injury and I'm in a coma. And so during the period that I'm in a coma, I clearly cannot think, I can't do. I briefly wake up, and during that moment that I'm awake, I know who my family is, I know generally about what I have, and I'm able to hold this all together in my mind long enough to write out something that says, I leave everything to my kids in equal shares, and immediately lapse back into the coma. Well, Lisa, although I was clearly incapacitated before and after, I had testamentary capacity because I knew those few things, and I had it at the time of execution.
That's right. And that example is so good, John, in the sense that how often do we have a family member come in and bring a will and they say, well, mom had already been diagnosed with dementia or Alzheimer's at the time she made the will. Well, the question is simply the diagnosis enough to take away a person's testamentary capacity? Absolutely
not. And this is something that's very hard for people to understand. And because people don't understand it very well, this can become a problem. Because again, you don't really, you all you have to know is those few things. And other things that may seem, For example, if maybe we have a lonely lady who's in her 80s, and at some point in time, this nice young man shows up and starts showing her a lot of attention, and she knows the nature of her estate. She knows who her natural heirs would be. She can retain all of this, but in being frail and lonely, and she's easily susceptible to the wiles of this young man who's showing her all this attention, and she decides to leave him everything, even though it was a con. He was just doing that so he could
get her property,
so he could get her stuff. But is that document valid? And it probably is.
Yeah, it probably is, certainly from a capacity standpoint.
From a capacity standpoint. Now, there may be other issues about undue influence and things like that, but that's not really what we're talking about. We're talking about whether or not you have the mental capacity. And the thing is to understand is that the level it takes to do this is very low.
That's right. The testamentary capacity that is necessary to do a will, to sign a will, to make your wishes known, get those down in writing, the testamentary capacity requirement, that's a very low level of capacity. Frankly, it's a lower level of capacity to make a will than it is to enter into a 2-year cell phone contract. So and I guess that kind of brings up our next question, John, is what kind of capacity does it take to enter into contracts? What happens when that fancy vacuum cleaner salesman shows up, or you get the telephone call about the great timeshare up in the Ozarks? Can a person who is elderly and maybe have some of those diagnoses of cognitive issues, can they enter into those type of contracts?
Well, and the short answer is yes.
Yes, that is the short answer. And we're going to come back in a moment and explain some of the details there, but some of the things that maybe a family member could keep in mind if they realize later that some of these contracts have been entered into. So stick with us and we'll be right back.
I'm so glad we found the Wadley Senior Clinic. Their team specializes in caring for older adults, and their doctors listen and work with me to keep me healthy and independent. With monthly educational programs, x-ray and lab, and state-of-the-art exam rooms, I get expert care and understanding about what I'm going through. Best yet, they're easy to get to right off the interstate at Jefferson. See what Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioners still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
Welcome back to Aging Insight. I'm Lisa Scholmeyer here with John Ross. And today we're talking about a very kind of sticky area. We're talking about capacity, the capacity of an individual to make choices, to make a will, to enter into contracts, to do powers of attorney. What kind of mental capacity does it take to do these things? And, does illness or the taking of pain medications, can those impact your capacities to do these things? And so, John, right before the break, we were talking about contractual capacity. That is the capacity to enter into a contract for buying or selling of goods, or the contract for services. Can a person who has a diagnosis of dementia enter into a contract for services? And
again, the short answer is yes. There's and it's going to be based on the facts and circumstances of the case. In order to cognitively enter into a contract, you have to understand what it is that you're doing. You have to understand the ramifications of it. So you have to know what you're doing and why you're doing it, and understand the ramifications throughout all of that. But a lot of times in these cases, it's not necessarily, you couldn't just hide behind the fact and you say, well, I didn't realize it was going to be this involved, or I didn't realize that, you can't just hide behind being 85 to say, oh, well, I didn't mean to enter into a 2-year cell phone contract because I didn't understand all the complexities involved there. But if you are able to understand that, yes, this is a contract, that, yes, you're going to have to pay money, then arguably it's probably a valid contract, even if it's a bad idea.
Right. I've worked with a lady who was in her 90s, and she sold some of her property to a buyer on a 30-year note that she was holding the note. And was that a real good idea?
Right. Not
Probably not.
Probably not such a great idea under the circumstances.
But she understood she had property. She understood she was selling it. She understood what the purchase price was offered by the buyer. And she understood that it was a 30-year payout. Now, she also understood she was 92 years old, so that she would probably never see the end of that contract.
Right.
But that's the contract she entered into.
Right. So what you should be getting a kind of an idea here is that when it comes to these sort of things, the issues are oftentimes, does the person have the ability to understand what it is that they're doing, even if that understanding is very fundamental. It doesn't have to be that they know everything about it, but do they have a general concept of what it is that they're doing? And you're looking at it at that exact moment in time.
Right, and that brings up the problem, doesn't it, John?
It does, because like we said earlier, oftentimes you find out about this months, years, decades after the fact.
So when we have someone who maybe has entered into a contract or a transaction, and we realize that maybe they were compromised somewhat, and the question is, we have to go back and look at that moment in time. At the moment in time that person entered into that transaction, can we pinpoint for sure that they were so compromised that they were unable to have a fundamental understanding of the nature of the transaction? Well, if you think about that, that can be very, very difficult to go back and prove, from later. Because we don't have a doctor taking notes at the time the contract was entered into of exactly the mental status of the person at the time the contract was entered. So it can be a very uphill battle, and we presume that these type of contracts and things are valid and intentional by the contracting parties. And we do that because, we don't want the state or our family members to second guess everything that we do as adults over the age of 18. So there's a level here of autonomy that we expect citizens to operate with, and most people want to operate with, but yet we do understand that there are some vulnerable folks out there that, because of age or illness, sometimes can enter into some contracts that really aren't a good deal for them.
That's right. And so this brings up a problem that's very difficult to solve, especially in our practice, which is, how do you make sure that a person who is frail and vulnerable but not completely incompetent, how do you keep them from messing up their own personal situation without robbing them of their fundamental rights? And this is very difficult. It does often involve a court procedure, but those court procedures don't have to be so black and white.
Right.
They don't have to be you're competent completely or you're incompetent completely.
Right.
The law is built to provide autonomy even during incapacity, so that maybe I can no longer handle my financial decisions, but I could still make decisions regarding where I live, or my medical treatment, or my right to vote, or even my right to marry.
Right.
Which with late life marriages is a big thing, but this is not necessarily something that you're thinking about right now when you're talking to mom or dad and stuff, but these are things that you should be talking about, and understanding what rights are important to you or what rights are important to that adult and trying to figure out how you're going to navigate through this system and through this maze when those cognitive functions start declining, and who's going to step in, and what rights are you willing to give up ahead of time, what powers, but which ones do you absolutely want to hold on to, even if you can't make any other decisions. Right. And that's a tough spot. It is, and there's no right or wrong answer to it. But the more you think about that ahead of time and the more plans you put into place to make that work, the less likely you'll find your decisions being made by somebody who does not know you and wears a pretty black shiny robe up at the courthouse.
Right. And you know, these days we are very much moving to a legal environment where we are wanting folks to be able to maximize the independence they have well into their retirement and elder senior years. But we do recognize that some of our skills do decline. So, you know, the courts are being asked to take a hard look at every single individual's circumstances to determine and make sure that those individuals continue to possess and operate the rights that they are capable of exercising, while putting in some protections perhaps to assist them in areas where they're not as capable. So, you know, that's what we're moving toward, and I'm glad to see it.
Yep, me too. Well, once again, you've watched another episode of Aging Insight. We hope you learned something, and we hope you'll tune in next week to a whole brand new edition of Aging Insight, and we look forward to seeing you then. Bye-bye.
Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Scholmeyer. This program is made possible by